So friends, do you think Donald Trump will ever stop confessing to his crimes? In his speeches, in his posts, in his media interviews? And are these statements admissible against him in court? Take it from this old prosecutor. You're damn right they are. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump just can't stop confessing to his crimes. And he's gone and done it again. Here's the new reporting. This from HuffPost. Headline, "Are you seriously this stupid? Legal minds nailed Trump after Fox News confession." And that article begins, Donald Trump on Sunday tried to defend himself from the criminal charges he's facing in the election interference case, but experts say it sounded more like a confession. Trump on Fox News bragged that his poll numbers go up every time he's indicted. Quote, "Who ever heard you get indicted for interfering with a presidential election where you have every right to do it, you get indicted, and your poll numbers go up," Trump said. Trump is facing charges in multiple jurisdictions and cases, including election interference in a criminal case filed in federal court in Washington. Last week, he was re-indicted to comply with directions from the Supreme Court, which in July ruled that Trump was immune from prosecution for official acts. On Sunday, however, Trump flat out said he had every right to have been interfering with the election. Lawmakers, former prosecutors, attorneys, and other legal minds were ready with a fact check, and some said it sounded like Trump was admitting to a crime. Representative Ted Lieu put it pretty bluntly. "Dear real Donald Trump, are you seriously this stupid? You think President Biden has the right to interfere in the upcoming election? Do you want VP Harris to do what you tried to get former VP Mike Pence to do? Are you really this dumb? Also, interfering in elections is illegal." Congressman Lieu is right about that. Interfering in an election is illegal. So now, friends, the question is, are these statements admissible in Donald Trump's criminal cases? And the answer is yes. Why is the answer yes? Because that is precisely what the rules of evidence provide. So let's do a quick Team Justice Law School class. I promise it will be a quick one. And we need to talk about two related topics: hearsay and what the rules of evidence call statements by a party opponent. First of all, what is hearsay? Well, the technical definition of hearsay is an out-of-court statement, a statement that's made out of court, that is offered in court as evidence to prove the truth of the matter asserted. Okay, that's a mouthful. That's a bunch of legal mumbo-jumbo, so let's break it down. Let's simplify it, and the best way is to use an example, a hypothetical. Let's assume that I'm at a diner with my friend, Peter, and I tell Peter, Peter, I saw our friend Joe kill that dude. And then the prosecutors call Peter as a witness in court to testify at Joe's murder trial. And the prosecutor asks Peter, well, what did Glenn tell you about what he saw? Hearsay, not admissible. Why? Because that's an out-of-court statement, a statement I made to Peter while we were outside of court, and the prosecutor is trying to present it as evidence in court to prove the truth of the matter asserted, to prove that I said I saw our friend Joe kill that guy, kill that dude. That's hearsay. That's inadmissible. However, The rules of evidence make an exception to the hearsay rule. They say if one party tries to introduce the statements of the other party, the party opponent, those kind of statements are exempt from the hearsay rule, the rule prohibiting hearsay. Those statements are admissible. So let's start with the rule regarding statements by a party opponent. And for anybody scoring at home, it is Rule of Evidence 801D2, and it reads, statements that are not hearsay. A statement that meets the following conditions is not hearsay. 2, an opposing party's statement. The statement is offered against an opposing party and was made by the party in an individual or representative capacity. Okay, now let's go back to Donald Trump's endless stream of confessions and admissions. We've been hearing him month after month, year after year, admit to many of his crimes. Every time he admits to something, like, you're darn right I interfered in the election and my poll numbers went up. That is a statement of a party opponent. Why? Because if the prosecutor tries to introduce Donald Trump's out-of-court statement in court as evidence to prove that Donald Trump interfered in the election, because the statement is being offered against an opponent, it's admissible. It is not hearsay. It is exempt from the prohibition against hearsay. That's what the rules of evidence provide. So yes, when Donald Trump says, I interfered in the election, that is a statement of a party opponent that can, and I promise you, will be admitted by Jack Smith and other prosecutors. Heck, if I were going to sentencing in the New York case, I would package that up as part of the submissions to Judge Merchan and say, well, look, Judge, there he goes again. He admitted to not only interfering in the 2016 election, which he was convicted of in this case in New York, falsifying business records to try to cheat in the 2016 presidential election. But in the unlikely event you thought Donald Trump might have any rehabilitative potential, there he is admitting to interfering in the 2020 election. The man is a demonstrated long-term chronic danger to free and fair elections in America. You're darn right I would package it up and introduce it. So that's why when Donald Trump, let me use another example. Remember how you heard Donald Trump say, you're darn right I took the documents from the White House when I left the presidency, hid them out in ballrooms and bathrooms in my third-rate resort down in Florida. You're darn right I took the documents. Those are admissions by a party opponent that can be introduced against him by Jack Smith. But here's what you need to know. Whereas Jack Smith can introduce the admissions and the confessions, the statements of Donald Trump, because he is the party opponent in the litigation, Donald Trump's lawyers cannot. They are prohibited from introducing Donald Trump's out-of-court statements, because those are hearsay. They're not being offered against the party opponent. They're being offered by the party trying to defend himself. Those are still hearsay. Those are still inadmissible. So Donald Trump, for example, could not bring witnesses in, nor could he put on videotape of his, hate rallies or his media interviews where he says things like, the Presidential Records Act lets me take documents from the White House when I leave the presidency. That's hearsay. Donald Trump and his lawyers cannot put that into evidence. So think about it. Any of the incriminating statements that Jack Smith or other prosecutors want to introduce that Donald Trump said, that's admissible. But anything Donald Trump wants to say to rebut or respond to that, he can't put on out-of-court statements. But here's what he can do. He can take the stand and testify. In theory, he can take the stand and testify, and he can explain it all away. Well, I didn't really mean I was interfering in the election. I didn't really mean that I took the documents from the Oval Office. he can explain it all away, and then he will get crushed like the bug he is on cross-examination, which is why you know he can't take the stand in the criminal cases in which he's being prosecuted. So the answer isn't Donald Trump confessing. Aren't those incriminating statements, can't they be introduced as evidence against him? The answer is, you're damn right, they can be and they will be. This is why Donald Trump is nothing but a miscalculation every time he opens his rancid pie hole and starts to spew nonsense into the public square. He is forever trying his cases in the court of public opinion, trying to fool the gullible, right? Presidential Records Act lets me steal our most, closely guarded national security secrets. No, it doesn't. I have a right to interfere in the election. No, you don't. But he just keeps trying his cases in the court of public opinion, continuing to try to fool and grift the gullible, right? That small segment of the American population who are either unable or unwilling to discern fact from fiction, lies from truth. They keep emptying their pockets $5 at a time and sending it to this abject grifter. But whereas he's forever trying his cases in the court of public opinion, I have been saying for a very long time now, friends, once his cases move from the court of public opinion, where there are no rules of evidence, there are no rules of procedure, there are no rules of law, once his cases move from the court of public opinion into courts of law proper, Donald Trump will be convicted in a New York minute on the evidence. And indeed, in New York, when the rules of evidence controlled what the jury could hear, not just what tumbled out of Donald Trump's mouth at any given moment, when the rules of evidence controlled, Donald Trump was convicted in a New York minute, in a New York courtroom, of 34 felony charges of falsifying business records to try to cheat in and steal a presidential election in 2016, and he will be convicted over and over and over again as soon as his cases go to trial, and they will go to trial, because we are going to get out and vote on November 5th in numbers too big to rig and too real to steal, and Donald Trump will then spend the rest of his days in courtrooms and in jail cells. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.